let me get this right. Airline alliances are okay, but shipping alliances are cartels. Or wait, airline alliances are also cartels, but because more consumers use it, they're okay? Have I mentioned that 90% of everything moves by ocean transit? Yes, likely even those pretzels that they serve on the airlines moved at least in part by ocean transit. Let's check the parallels here, because if you're going to go for one, you might as well go for both. And I don't think you're going to get a lot of support doing that. Let's learn more. Hi, welcome to By Land and by Sea, an attorney breaking down the week in supply chain, presented by the Maritime Professor. That's me. I'm Lauren Beagen, founder of the Maritime Professor and Squall Strategies, and I'm your favorite maritime attorney. Join me every week as we walk through both ocean transport and surface transport topics in the wild world of supply chain. As always, the guidance here is general and for educational purposes only. It should not be construed to be legal advice, and there is no attorney-client privilege created by this video. If you need an attorney, contact an attorney. So before we get into the discussion of the day, let's go through my top 3 stories of the week. Story number 1, it's a repeat, OSRA 22, Senate version passed and signed into law. I wanted to repeat it because it's that important. Remember, this was the Senate version. The version was a little less restrictive than the original House version. This version gave the FMC, the Federal Maritime Commission, a little more deference to determine unreasonableness standards and directed them to do a whole bunch of rulemakings. You know, I still would have liked to have seen more time in deliberations, but, you know, I think I like the final Senate version, and there are some good improvements there. One major piece missing, I keep saying it, giving the FMC the authority to deny alliances when they're filed, or even periodic renewal periods for the alliances. Said it before, I'll say it again. This is where the conversation begins. Not a terrible start. You know, one thing that is moving towards being a very big deal here, though, was, and almost maybe seemingly overlooked, the OSRA bill as written and signed into law had very specific guidance on what is required in an invoice for detention and demurrage billing. And it included 2 statements. So I had a whole list of things that were now required as of the signing of the law. Date the container is made available, port of discharge, container number or numbers. I mean, these are basic things. They probably should have already been there, but also includes for exported shipments, the earliest return date, the allowed free time in number of days, the start time of the free time, the end time of the free time, the applicable detention and demurrage rule on which the daily rate is based, the applicable rate or rates for the applicable rule, and the total amount due, and the email, telephone number, or appropriate contact information for questions or requests for mitigation of fees. Now, you know, the first few seemed, well, why wouldn't they be there? The rest just round out probably a good idea of information that should be on these invoices. But these last 2 statements, I just wanted to point them out. I know this is the hot topics of the week. But so the 2 statements are a statement that the charges are consistent with any Federal Maritime Commission rules with respect to detention and demurrage. Okay, so it's basically saying, you know, kind of a qualifying overall statement. These are consistent with FMC. And then this next statement says a statement that the common carrier's performance did not cause or contribute to the underlying invoice charges. Now, okay, well, if you're a common carrier and you're issuing an invoice, that makes some sense. But what if you're not the common carrier issuing the invoice? What if you're an operating port and now you have to put on your invoice a statement that the common carrier's performance did not cause or contribute to the underlying invoice charges? Isn't that kind of a shifting of I'm just going to put on my statement that those guys are fine? I don't know. You know, this is a little, these are the kind of crossed T's, dotted I's that maybe it might have been a crossed I moments. You know, in general, I'm happy with OSRA, but I think we're going to find maybe a few more of these little things. Again, that's why I liked OSRA 98 in procedure alone. It took 8 years to get through what ultimately became OSRA 98. So Ocean Shipping Reform Act of 98, that was a modification of the Shipping Act. This one, OSRA 21-22, now OSRA 22 is when it was passed, was just over a year. Different worlds, different scenarios, but, you know, it's just the amount of time that you spend with it, you're going to have some of this stuff cleaned up. But, you know, that's all right. But I wanted to bring that to your attention. So, you know, this is important that we note that these invoices also went into effect. These invoice minimum materials went into effect right away. That as soon as the law was signed, it was already a law. It was already something that you had to do. So arguably, and granted, this is educational purposes only, but arguably those invoices, if you don't have all those things listed, they might be defunct. So this is something to watch. As the law is written, basically it does say the invoice is defunct and that you may not have to pay it. But look, again, this is not legal advice. You need to contact an attorney if you have questions on this. But as a general matter, this is creating some very questionable gray area. Early unofficial reports are that this reading of this immediate effect is real, and that the FMC may be issuing some guidance or a policy statement on this in the near term. More to come, but my general non-legal educational advice here: clean up those invoices, make sure that you have all of this billing information listed, and where it makes sense, put those statements in. These are now statutory requirements for detention and demurrage invoicing. So I recommend, as general educational advice, that you know what's required of you now if you are issuing invoices for detention and demurrage. That was just story number one. Story number two: now that the Ocean Shipping Reform Act has passed, in multiple conversations this week, I was told that alliance antitrust immunity might be up next. I don't know. This makes me nervous. I don't think this is the answer. And certainly this needs to be not for political reasons. I was ultimately okay with the expediency of OSRA passing. We just talked about that. But, I didn't love how fast it went. But, going after ocean alliances with anything less than a year of deliberations, and I mean like real reports, studies, examinations, bringing in consultants, reviewing economic benefits or detriments, anything less than that is too little. This is going to have global ramifications. So Hong Kong did a review as well. They were cleaning up all of their competition authorities, their competition laws, and ultimately decided to keep a block exemption for ocean shipping reform. Maybe one of these days I'll go more further into Hong Kong and the competition authority. The European Union also has block exemptions for ocean common carriers for these alliances. All of these countries have closely reviewed these alliances. This isn't a uniquely US thing, so we shouldn't probably be so singular in our thinking here. Maybe a global regulatory summit is in order. We just had one, what was it, last year? So the Federal Maritime Commission meets with our European and Chinese counterparts, and that's where they sit down, and they were really started when alliances were just beginning to form. Maybe it's now time to come back together because other countries are starting to have these questions, and these, our alliance is still asserting the benefits that they once did. But you know what? I don't know. Congress jumping in here is probably not the solution. There's too many politics. Congress is a little too removed from the industry. This really needs to be an industry solution. I'd like to see the solution come from there. Maybe Congress ultimately passes a law, but there needs to be. It just makes me nervous. This is so huge. Antitrust immunity that ocean shipping alliances have is so much bigger than just a little bit of trouble that we've been having. And I say a little bit of trouble respectfully. This has been major trouble. These rates are out of control, but the FMC is getting there. I mean, we have so many new authorities for the FMC. We have so many more directives. We have rulemakings. They're going to be rulemaking, left and right. They're going to be eating, sleeping, drinking rulemakings, especially over the next 30, 45, 60 days. Let's let those take an effect before we do something drastic. And that's my only concern. That's my only worry and caution here is that, I see that as a little bit more on the drastic side. Maybe it is the solution, just not for right now. These are heavy stories, huh? So story number three is actually something that I've been curious about. So surely the operational costs of ocean carriers didn't rise as quickly as the freight costs, but I was kind of wondering, how much did they rise? So my question was answered. The Financial Post reported this week that Vincent Clerc, chief executive at Maersk, told not the chief executive officer, but one of the executives at Maersk, told the Consumer Goods Forum Global Shipping Conference in Dublin, Ireland this week, that the break-even point for Maersk's movements of goods rose about 25%. And he also said that he actually doesn't expect their operational costs to return to pre-pandemic levels. That's interesting. So does this also mean that the ocean carriers having negative profit and loss years won't return either? As you may recall, we talked about that before. These billion-dollar profit years are new, and formerly ocean carriers were lucky to break even some years. So up 25%. At least that's at the largest container shipping company for Maersk. So, their break-even point has risen 25%. There's still some inconsistencies, obviously, with 1,000% increase on freight rates. But, it's something to understand and to keep into consideration as we start building for the long term. Their cost did go up too, and not the 1,000%. And we got to get a handle on that. So let's get into the meat and potatoes of the day, huh? So we had a lot of conversation. I've had a lot of conversations over the past few weeks with both industry friends and actually just general friends about alliances. Yes, general friends are asking about shipping. Aren't yours? And whenever I try to explain the shipping alliances, I actually find myself using airline alliances as the parallel. All air travelers have heard of the Star Alliance or SkyTeam Alliance or the One World Alliance. These are all operationally shared international operating alliances. I'm going to say that again, operationally shared international operating alliances. So I thought this week, wait, why are these air alliances okay, but ocean shipping alliances aren't? Or, at least that's been the trend recently with so much talk about ocean alliances being cartels. So I thought I'd look into it. I'm an ocean expert, I'm an ocean shipping expert, but if I find a parallel to alliances on air, I'm going to kind of check it out. So, I'll draw some parallels as we go along here, but I want to kind of share what I found. So when you actually just approach it from the beginning, when you Google who regulates airline alliances, you're brought to the Department of Justice, the United States Department of Justice, their antitrust division website. So that's a good start. And by clicking through to the website, you're brought to a page, Antitrust Immunity and International Airline Alliances. So there's an actual discussion paper there. It's an economic analysis group that's titled Antitrust Immunity and International Airline Alliances by William Gillespie and Oliver Richard. The paper's from 2011, but it's still up and it's still part of their economic analysis group, which they describe as actually the primary vehicle used to disseminate research from the economists of the Department of Justice Antitrust Division. So here's a parallel. So the Department of Justice Antitrust Division has economists. That's what they're telling us. They say they put out reports. The Federal Maritime Commission also has economists. There's quite a few economists. For a while, it almost felt like the FMC had just as many economists as they did lawyers. The FMC obviously has lawyers, and you already know it. The Department of Justice has lawyers. So what does it say? So what does this report say? This economic analysis group, this report that's called Antitrust Immunity and International Airline Alliances, it says through the U.S. Congress transferred jurisdiction over airline mergers from the Department of Transportation to the Department of Justice in 1988. So DOT retains the statutory authority to approve and immunized from the U.S. antitrust law agreements relating to international air transportation. So that's what they're saying. So the Department of Transportation still retains the authority to approve and offer antitrust immunity through requests. There's no corresponding authority for DOT or DOJ, Department of Transportation or Department of Justice, with regard to domestic alliances between U.S. carriers and domestic alliances. So domestic alliances don't have antitrust immunity. That's interesting. No antitrust immunity for domestic alliances, only international alliances. I'm only stopping here because this is one of the critiques of ocean carrier alliances, that they were foreign and that it's a bad thing because we should prioritize U.S. I mean, if we only even had an ocean carrier that was a U.S. flag, international ocean carrier. So let's go on. So Department of Transportation has granted antitrust immunity over the past 17 years. This is higher now given the age of this report, to participants in over 20 international alliance agreements, including the participants in the three major alliances. We talked about that. So some major carriers in each of the SkyTeam and Star obtained grants of antitrust immunity in the 90s and early 2000s, and since late 2008, more major carriers have been granted antitrust immunity within each alliance. So basically, all that is saying is that these have been going on for a while. They've had antitrust immunity since the 90s, early 2000s, and really even 2008 was when they had their last real big round. So in 2011, here were the steps. And I give the caveat of this was 2011 because this is cursory research, because it's illuminating a point. Look, I'm not an aviation expert, not yet anyway, but I wanted to look for parallels or maybe best practices, acceptable levels of alliances and alliance activities, if you will. So continuing on with this report, Department of Transportation, DOT's review of international alliance agreements has 2 steps. So the first step, DOT determines whether an agreement substantially reduces or eliminates competition. It's kind of what we think of when we think of antitrust. So antitrust is monopoly. So substantially reduces or eliminates competition. So if it does this, the report continues, the Department of Transportation must disapprove it unless DOT finds that the agreement is necessary to meet a serious transportation need or to achieve important public benefits. So a few things I want to call out here. So one, they determine whether the agreement substantially reduces or eliminates competition. That's the whole monopoly side of it. But then they say that they're allowed to disapprove it. Didn't I say that earlier? Haven't I said that a million times? The FMC doesn't have the ability to disapprove alliances. They get filed and they have to file an injunction against them if they'd like to stop them. So they basically are automatically put into play 45 days after the filing. You can toll for questions, but really 45 days after it's filed, this alliance agreement is going to go into effect in the ocean carrier world. On the aviation world, it looks like they can disapprove it. Department of Transportation can disapprove it unless it finds that the agreement is necessary to meet a serious transportation need. So even if it finds that it substantially reduces or eliminates competition, if it's still necessary to meet a serious transportation need or to achieve important public benefits, and there's no less anti-competitive alternative or there's no less monopolistic alternative, they could still approve that. So if Department of Transportation approves this anti-competitive or monopolistic agreement on these grounds, then it actually has to exempt it from the antitrust laws, because that's what they're saying. If this is so monopolistic, if you're going to approve it, you have to exempt it from the antitrust laws. So second, this is only the second stage. Second, for Department of Transportation, if Department of Transportation finds that an agreement does not reduce or eliminate competition and is consistent with public interest, then DOT must approve it. So let's say it again. So that if the Department of Transportation, DOT, finds that an agreement doesn't reduce or eliminate competition, so it doesn't seem to be monopolistic, and it's actually consistent with public interest, then they're required to approve it. But exemption from the antitrust laws is authorized only if it is required by the public interest. So this is where, it's a little bit confusing here, because it's basically saying if it's not monopolistic or doesn't really act monopolistic and it is consistent with public interest, they must approve it. But exemption from antitrust laws is only authorized if required by the public interest. So antitrust laws would be there because the immunity from it, because they act monopolistic, but we're going to say, don't worry, we're not going to come after you for being a monopoly. This is a little bit squishy here, because it's like, well, you're saying it's probably not monopolistic, and don't worry, we're not going to go after you even if it is, but we told you that it wasn't. So even then, immunity is authorized only to the extent necessary to allow the person to proceed with the transaction specifically approved by the order. So it gets a little, just in case you might be language. So Department of Transportation's review thus encompasses both a competitive analysis of the transaction and public interest considerations. So that was the report. I kind of like this public interest consideration because it brings in the industry. It brings in the public need. Aviation, air travel is, arguably a necessity for today's day and age. Ocean shipping, 90% of everything, is definitely a necessity for just the general good of society. The whole globe. So there are these for the better of the general good arguments, but also does not reduce or eliminate competition determination. So there's that monopolistic. Arguably only the second is what is in play for the ocean carriers, and maybe the first prong should be incorporated, this general good. I said it earlier, I'm going to say it again. Did you note that the Department of Transportation can disapprove? This is something the FMC cannot do. They cannot disapprove of an alliance agreement. They have to. The FMC, if they don't like an alliance agreement that comes through, they have to file an injunction against it for the agreement to not even go into effect. And even then, it's not a guarantee, and it's pretty cumbersome to an already overtaxed and understaffed agency. This is what I'd like to see. If we are going to start attacking how to clean this up, the FMC should have this disapproval mechanism, because what if an alliance agreement was filed? Not saying that it would be or could be or should be, but what if an alliance agreement was filed Two of the major alliances have now joined together because they say, well, they hate us anyways, we might as well join together. Now they have 70% market share. I mean, the FMC can't disapprove it. This is where it gets tough. So obviously they're going to be filing suit, and then it would play out in due course. But this is just to have that stop button earlier. I think it's important. So we continue. So I go over to the Department of Transportation's website. That's where the authority lies, the first instance. So let's find out more. So alliances, major U.S. and foreign air carriers may, under certain statutory authority, request a grant of immunity from the U.S. antitrust laws to operate certain commercial airlines. This is on the DOT's website. Immunity allows these airlines to coordinate their fares, services, and capacity as if they were a single carrier in these markets subject to certain conditions. Did you read that? Did you hear that? Coordinate their fares, their rates. That's money. This is joint rate setting. This is something that the ocean carriers are definitely not allowed to do. Ocean carriers, for the most part, stay operationally sharing of information. They vessel share, they share their space. They coordinate together so that you can really kind of have more options as a shipper, as a consumer in the ocean carrier world. This is allowing, on the aviation side, coordinating their fares. I don't know. This is where it starts to get a little, I'd like to know more. Airline alliances are okay, and ocean carrier alliances are cartels. But arguably, I'd say rate setting coordination, and like it says on the website, as if they were a single carrier in these markets. I mean, that sounds more cartel-y. And it's not saying that the aviation airline alliance authority or mechanism is wrong. I kind of like it. I think it's pretty good. But I just want to be fair to the ocean carrier side of things. The FMC came out with that report saying that there was vigorous competition. I think I'm gonna dive back into Fact Finding 29 a little bit deeper, but it didn't sit right with me that people were calling into question, because both the Department of Transportation, the Federal Trade Commission, and the Federal Maritime Commission. So the DOJ, who's part of this airline alliance, authorizing, reviewing side of things. I mean, the DOT is the first instance, but DOJ is part of that, said on the ocean carrier side, they agreed that there wasn't monopolistic behavior or that there wasn't a competitive reduction, that it was, they didn't specifically say vigorous competition, but in the report on Fact Finding 29, it was agreed with that DOJ, FTC also found that there wasn't a reduction in competition. So again, the fares. It also says, and I just highlighted this, but it also says as if they were a single carrier in these markets. Arguably, isn't that kind of basically allowing a merger without it actually being a merger and just not being subject to the antitrust, the monopolistic laws? So Department of Transportation continues here. So we're reviewing what DOT does in aviation alliances, and we're trying to draw parallels here to the ocean carrier side of things. So when DOT continues, when evaluating these applications, we normally engage in a two-step analysis of foreign air transportation agreements submitted for our approval. We talked about this just a minute ago. This is reiterated here. We first DOT determines whether the agreements are adverse to the public interest because they would substantially reduce or eliminate competition. This is the competitive analysis. This is arguably what the ocean carriers have to go through: substantially reduce or eliminate competition. If DOT makes that affirmative determination, the statute then directs them whether they are necessary to meet a serious transportation need or to achieve important public benefit. I'm reiterating this. This is actually on the website. This is statutory authority. I kind of like this, don't you? I'd love to hear what you think. If you are an aviation expert, I'd love to hear more about how this works. If I'm getting it totally wrong, please let me know. This is a conversation, but I kind of like this, and I think that maybe this could be used as a parallel for how we move forward with Ocean Carrier Alliance review, if that's something we want to do. Like I said, this needs to be done very carefully. So DOT continues, if we make a finding and also find that these public benefits cannot be met or achieved by reasonably available or materially less anti-competitive alternatives, so other less monopolistic, then DOT has to approve the agreements. They even have an avenue for somebody opposing approval of the airline alliance. So providing that a party opposing approval has the burden of showing that the agreement or request would substantially reduce or eliminate competition. So if you think that one of these alliances, these aviation alliances in this example, is actually substantially reducing or eliminating competition, then that less anti-competitive alternatives are available. You can stand in, you can speak up, you can submit information here. On the other hand, the party seeking approval of the agreement, the party who's sought the alliance, the aviation alliance, must establish the transportation need or the public benefits. So DOT continues, if, however, we do not find that the agreement's to be adverse to the public interest, the statute directs them to approve it. So in that event, we next decide whether there are sufficient public benefits to grant immunity under the public benefits analysis. So in that subsection, Congress has given the Department of Transportation the authority to exempt airlines from the antitrust laws to the extent necessary to allow a proposed transaction to proceed, provided that the exemption is required by the public interest. So even if it seems like the competitive analysis puts this in a do not go, but that the public benefit analysis outweighs that monopolistic, it could still move forward. This is really illuminating, isn't it? This is really interesting. So, a grant of antitrust immunity is not automatically given to applicants. Moreover, an alliance which has received immunity is required to comply with the operating constraints and reporting requirements specified in the final order. And that's the final word from the Department of Transportation's website. I said it. I like this approach. It balances public benefit with anti-competitive events. And there's also a disapprove measure, but I like that balance. I like that there's some discussion, there's some analysis, there's some public utility, there's some public benefit. And I just can't say it enough. There's this disapprove measure. Also, as a special note, the Department of Transportation has engaged in a joint study of transatlantic airline alliances with the Directorate General of Competition for the European Union, the European Commission. So that's DG Comp. So this was a transatlantic airline alliance, competitive issues and regulatory approaches, published in 2010. This is actually the same office, this DG Comp, that the FMC works with when they do the Global Shipping the Global Regulatory Summit. So this is DG Comp of the European Commission of the European Union. So we're working with, in this aviation example, we're working with the EU on airline alliances. But, if we were to change our ocean alliances without consulting DG Comp or China or any of the Hong Kong Competition Authority, we could potentially be working adverse to them. So we're working with them on aviation and against them on ocean alliances, which, I'm starting to see some parallels here. And actually, in a statement of November 24th, 2021, so what's that, just under a year ago, the European Commission reported to the European Parliament that they were, quote, aware of the material price increases for container shipping, the level of service quality in the maritime supply chain, and the related difficulties for European producers and consumers. So similar experience that they're having in Europe, obviously, that we're having in the US. And within the realm of its powers and competences, the Commission, the European Commission, is willing to address the concerns about the functioning of the supply chain, ensuring Europe's competitiveness. So the European Commission continues. This is a report to the European Parliament, so both bodies of the European Union. It has at this stage not received evidence or identified anti-competitive behavior in relation to these price increases. A similar conclusion has been reached by other key agencies, for example, the Federal Maritime Commission of the United States. So the European Commission is saying the same thing. They have not received evidence or identified anti-competitive behavior in relation to these price increases. I know it's tough. We all want to find that smoking gun, but this isn't it. So, the European Commission states that they haven't seen anti-competitive behavior, and they bring in the Federal Maritime Commission saying that the FMC hasn't until this point either. So they continue. The European Commission, entertains regular dialogues with stakeholders and maritime authorities from many jurisdictions, both inside and outside the European Union, to exchange views on actions to increase the resilience of the sector. Dialogue partners have generally agreed. This is what they said. Dialogue partners have generally agreed that the pandemic has presented operators across the supply chain with exceptional challenges, that the causes of the price hike and of the current level of service quality are multifaceted, not necessarily entirely similar across the world, and hardly attributable to only one determining factor or one category of operators. the European Commission will continue exchanging information and promoting joint analysis of the markets with stakeholders and maritime agencies. I'm building to the point here that we need to be very careful if we're going to be changing our methods for alliances and antitrust immunity. European Commission is saying the same thing. We haven't found a smoking gun. We haven't found one thing that is the problem. It's a cleanup of the whole system. It's a cleanup of surcharges. It's a cleanup of invoicing and basic minimum requirements of invoicing. We're also desperate to find that smoking gun, but like I said, maybe it's just not there. It's not just the US that hasn't found this anti-competitive, or like I said, another way, this monopolistic behavior. Sure, the services actually sucked for a while. I get that. No, I'm not diminishing how terrible it's actually been as a user experience. But yes, there were bogus surcharges. And I've said it before and I'll say it again. The FMC is getting to it. The Federal Maritime Commission is getting to it. The new OSRA directives will help clean up some of this. The OSRA, Ocean Shipping Reform Act, has some high demands for the Federal Maritime Commission in terms of timelines. So they're going to be forced to move quickly here. So what is antitrust immunity anyway? So basically, it's when businesses work together in an otherwise unfair way, but for some reason it's allowed to continue. So something's missing from my quick analysis here. That was kind of the regulatory, how we approach things. But what is the market share that the airline alliances have in the general market? I don't have the exact numbers. It was hard to kind of in my cursory looking through. And like I said, I'm not an aviation expert yet. But in general, the European Commission likes to see a low 20% number as kind of a blanket statement. DG Comp seems to like a 25% number. And I was finding mostly numbers of mid-low 20%, 22, and even as low as 16% for the One World Aviation Alliance. Collectively, the numbers that I was finding was that all three of these aviation alliances made up only about 60% of the market. So ocean alliances are actually just a little above that. They make about 80% of the total market. So, to be fair, there's a difference there. The aviation alliances, all three of them make up about 60% of the market, whereas the three ocean alliances make up about 80%. And they all stay around 20-ish, mid to high 20% of the market share. Whereas, the aviation, like I said, is a little bit more 15, 18, 20, 22% of the market share. Look, my point here is that there are some major repercussions if ocean alliances and their antitrust immunity is messed with. And we need to be very careful. And I mean very thorough, very globally focused, very understanding of the repercussions if we do go this route. I talked about this a little bit at the beginning. Hong Kong almost did away with alliances being allowed, and it was a big shakeup. This all happened in 2015. And after a big study, they actually decided to keep the block exemption. So they essentially said, we were just going to say all alliances, you can't have monopolistic behavior. You're not going to have any sort of antitrust immunity. If you are a monopoly, we will treat you as such. And if you have anti-competitive effect, if you're working together as big companies, we're going to go after you as such. They did a big study. Hong Kong did a big study. They decided to keep the exemptions for the ocean alliances. Like I said, maybe I'm going to go into a foreign treatment of ocean alliances and antitrust immunities in another episode. I don't know. There's a lot of really great parallels. There's a lot of really great studies that have been done on this. I mean, this has been going on since 2015, 2016. I believe it was March that I did my ocean alliances overview. Maybe it's time to brush that off. Go back to the By Land and By Sea YouTube page. I'm hoping to get all this up on podcasts so that you'll have better cataloging and we'll be able to find some of these old discussions easier. But look, I'd love to hear your thoughts on all of this. Airline alliances and their parallels, or is it too dissimilar from ocean shipping? Is this too basic of an understanding that I have? Did I kind of approach this with too large of a overview? I mean, did I oversimplify this? I'm open-minded here. But I've just been really close to the alliances, particularly the ocean alliances, particularly during the years that they were being created. And I'm just so hesitant to see them being unilaterally potentially done away with. And I don't want to be overly dramatic here. And I don't want to be overly, maybe we're going to be just fine. Maybe the alliances aren't going anywhere. And I don't mean that as we'll be just fine, but maybe the alliances really aren't going anywhere. But look, I'm just so hesitant to see them be anywhere near a quick discussion. I said this last week. I'm going to say it again. We all need to enter into the next few months with our eyes wide open. We're heading into an election year, and there's going to be a lot of misinformation. And modifications to antitrust immunity of ocean common carriers has no room for political rhetoric. This is purely business and should be treated as such. This is arguably the backbone of all goods used all over the world. And this is important. We need to really know what we're doing. This needs to be a very large discussion if we're going to be changing some of the ocean carrier alliance antitrust immunities. That's it. Let me know what you thought. Let me know if you know more about the aviation alliances world. Is it so different than the ocean carrier world? I mean, we have consumers and everybody going on aviation, and we're arguably, not many people actually get out on a ship, so they don't see it firsthand. I don't know. I thought it was interesting. I wanted to pass it along. As always, the guidance here is general and for educational purposes. It should not be construed to be legal advice directly related to your matter. If you need an attorney, contact an attorney. But if you have specific legal questions, feel free to reach out to me at my legal company, Squall Strategies. Otherwise, for the non-legal questions, e-learning, and general industry information and insights, come find me at the Maritime Professor. If you like these videos, let me know. Comment, like, and share. If you missed any previous videos, these videos live on my YouTube page by Land and by Sea, presented by the Maritime Professor. And while you're at it, check out the website, themaritimeprofessor.com. So until next week, this is Lauren Beagen, the Maritime Professor, and you've just listened to By Land and by Sea. See you next time.